Hello, the government has proposed legislation to replace the existing Human Rights Act with a new British Bill of Rights. It says it will strengthen freedom of speech and curb bogus human rights claims. Critics say it's an attempt to put the government above the law. To help us make sense of this, I'm joined by the Institute's Head of Research, Dave Greatorex, and our solicitor advocate, Sam Webster. Thanks both for speaking with me. Dave, let me start with you. In the UK, we rely upon a system of checks and balances between the executive, the government, the legislature, parliament, and the judiciary. How is this bill going to affect that?
Yeah, so the government has been expressed, it's actually in clause 1 of the bill, that this is something of a rebalancing between the courts and parliament, and also with the European Court of Human Rights. So the government says it's concerned that where the courts have interpreted legislation to be human rights compliant or compatible, that the courts have actually gone too far and that they've been thwarting the will of Parliament. And so the way legislation has worked in practice has not been how Parliament intended it to work. So that's what the government says it's trying to address in the bill. Another key justification the government gives for the bill is to enhance protection for freedom of speech within our constitution, within our society. And so there is a section in there saying that free speech must be extra weight given to free speach.
There's been some concerns raised about free speech as well, hasn't there?
Yes, so, and I think that comes down to the interaction of those two things. So the rebalancing on one hand and the increased protection for free speech on the other. Because the question is, if in that rebalancing you're increasing deference to Parliament, so the courts just have to take Parliament's word for it that they've struck the right balance between competing rights, to what extent are the courts really going to be able to hold the government and its legislation to account against free speech?
Okay, well, let's talk about the European connection. You touched on it very briefly. This is not about the European Union. Let's make that really clear. This isn't a Brexit thing. But there is an effect insofar as the relationship with the European Convention on Human Rights, because what the Human Rights Act 1998 essentially does is enshrines into UK law a set of principles, laws that are set out in the European Convention on Human Rights. And this act is going to remove the Human Rights Act.
That's right. So the Council of Europe is what the European Convention on Human Rights is under, so completely different to the European Union. We're still one of 46 members of the Council of Europe, and we signed the European Convention back in the early 1950s, having had a key role actually in the drafting and creation of that convention. And what the Human Rights Act 1998 did was to give further effect to the convention rights. And that meant that rather than having to go to the European Court of Human Rights with a human rights claim, you could do it more easily through the domestic courts. And the Bill of Rights doesn't change that. That will still be the case. You'll be able to access convention rights through the domestic courts. The bill has all the convention rights in a schedule. They're very much going to be part of our law. So that is not changing.
Okay, let's talk about the positives. And free speech is clearly a big, I've taken on board your caveat from earlier, but free speech is clearly a big area that's a positive for us here. Yeah,
so we can see the potential for this increased protection for free speech. So it doesn't change the baseline of Article 10, which is the Convention right on free speech. That's still there, and it just adds an extra gloss on it in terms of the weight that the courts have to give to free speech. So that's obviously going to work well for us. We can see it working positively in some of the street preacher cases that we've taken, for example, where it's a question of unlawful arrest. Wrongful arrest.
You mentioned Article 10. Well, obviously, that was crucial to Ashes.
Yes, yeah, and that was the basis. So Article 10 includes compelled speech, and so that's the right not to have to say something that you disagree with, as well as the right to say things that you wish to say. So Ashes was very much based on Article 10, and so we can see a stronger role then in cases like Ashes for free speech as well.
Does it do anything for compelled speech?
Not expressly, and I suppose that's one area where we could see the bill could be improved to make express reference to compelled speech. But compelled speech is still there within Article 10.
Okay, well, let's talk about some of the concerns. Sam, if I could turn to you. Two significant areas of concern are the court's ability to read down from the convention, and the court's ability to deal with laws which are argued to be incompatible with human rights law. The ability to read down is essentially being removed. Can you just explain, first of all, what it means to read down law and what the significance of that change is? So in the Ashes case, I was just talking about with Dave, reading down from the Convention rights was a significant part of that. So how does what's being proposed change all of that? But perhaps you could just start with this explanation of reading down.
We need to start with the Human Rights Act 1998. Section 3 requires the courts, insofar it's possible to do so, to read all legislation in a manner that is compatible with the European Convention on Human Rights. Now, in some cases, that may involve courts reading in the odd word, reading in order to make it read in a manner that is consistent with the European Convention. In other cases, as you say, Ciarán, it may involve the courts reading down. So where there's a range of possible interpretations of the statute, they may need to read it in a manner, perhaps the preferred reading, which would give effect to the European Convention rights of the parties concerned.
This term reading down is really about just how something which is already in law is understood in a different context.
So the judges mustn't overthrow the intent of the statute. Mm-hmm. They mustn't do violence to the wording of the statute. But sometimes there may be nuances of meaning Parliament hasn't perhaps thought through precisely in terms at the legislative stage, and it's given effect to the will of Parliament, but at the same time, perhaps given that wider picture of human rights, a greater say in the way that things are interpreted.
Okay, so how is this change going to affect all of that?
So Section 3 of the Human Rights Act, the ability to read down legislation will be repealed under the Bill of Rights Act. It won't be replaced, and the Bill of Rights bill is very clear that the courts will no longer have that power to construe legislation in a convention-compatible manner. So going back to the Ashes case, which it was Section 3 of the Human Rights Act was very instrumental in getting the court to the position of deciding that Ashes Baking Company were not liable for political opinion discrimination. In future cases, that tool will be gone. They will no longer be able to do that.
So Christian Institute supporters listening to this might immediately start to feel rather alarmed. Ashes was a big case, lots of publicity. Are we saying that the Ashes case would come to a different conclusion because of this change?
So even before discussing the Human Rights Act in the Ashes case, the Supreme Court had already expressed doubts that this was a case of political opinion discrimination. What Section 3 of the Human Rights Act gave the court was a clear basis, an easy basis, if you like, a very short basis to find in favour of Ashes Baking Company. So in future cases without Section 3, I think that they certainly have to do a lot more work in terms of applying some of those basic principles to get to the same result.
But there were lots of strong legal arguments in favour of Ashes, so people shouldn't be concerned.
Yeah, and the question about Section 3 obviously goes to the core of what the government is saying about the courts thwarting the will of Parliament. But if that's the case, then there must be a way to narrow the application and the use of Section 3 without scrapping it altogether.
Which is what they actually set out in the consultation.
Yeah, the consultation had a couple of options, narrowing rather than scrapping. So.
Okay, right, Sam, let's talk about that incompatible legislation point. As we know, I think everyone would agree that politicians don't always get it right. And the named person legislation was an example of that. So what's going to change to ensure that courts are still able to deal with legislation which is incompatible in relation to the European Convention of Human Rights? So to put it another way, If the named person scheme was coming into place in a post Bill of Rights world in England, what would be different?
Well, we've just been talking about Section 3 of the Human Rights Act. Insofar as it's possible to do so, the courts must construe legislation compatibly with human rights. Sometimes it's not possible to do so, and the court is left in a place where it's got legislation that it's required to interpret and to apply, which is incompatible with the European Convention on Human Rights. In a situation like that, at present, under the Human Rights Act, the court may make what's known as a declaration of incompatibility. If such a declaration is made, what it is that the court's saying, we don't believe this is compatible with the European Convention. The law is still valid, it's still on the statute book, but the matter then passes back to the politicians. And the politicians, Parliament, must decide whether or not they amend that legislation or repeal it or whatever in order to remedy the situation as found by the courts. Now, under the Bill of Rights bill, what will happen is Section 4 of the Human Rights Act, the ability to make declarations of incompatibility, that power will still exist. But the new bill will substantially restrict the ability of the courts to make such declarations. So there's a new provision in the Bill of Rights which says basically that the courts must regard Parliament in passing the legislation that they're interpreting, the courts are interpreting, they must regard Parliament as having already struck an appropriate balance between conflicting human rights and between conflicting human rights and policy aims by government. That does raise substantial questions in the future as to in what circumstances will the courts feel able to make declarations of incompatibility.
Mm-hmm. It's a very high threshold.
It could substantially raise the threshold for courts, yeah. So one's left wondering, what would those circumstances be? Mm-hmm. If Parliament's presumed to have got the balance right already. So if we, as you mentioned, Ciarán, if we had a named person type situation in England, at the moment, under the current law, one would seek a declaration of incompatibility under the Human Rights Act. Mm-hmm. After this new legislation goes through Parliament, I think it would be very difficult to challenge a named person type scheme were it to appear here in England.
That's a real worry.
Yeah.
That's a significant concern, isn't it?
It's also important to just to note that the named person challenge in Scotland was not in fact brought under the Human Rights Act, but in fact brought under particular constitutional legislation that applies to Scotland, given that it has a devolved parliament. It was brought under the Scotland Act 1998.
So no change as far as Scotland
is concerned? So far as Scotland, Northern Ireland or Wales is concerned in terms of challenging incompatible legislation.
Okay. So we've covered the sort of the rebalancing and the free speech points. We've talked about the reading down and reading in, how that might change. We've talked about incompatible legislation, which is quite a lot of ground to cover. Is there anything else that we should be concerned about? What about the specific religious freedom protections in the Human Rights Act? How are they affected by this? Are they affected?
Yeah, so Section 13 of the Human Rights Act, as it stands, says that courts, when they're considering questions of how convention rights apply, must give particular regard to the religious freedom of religious organisations. And there are question marks over how that has worked in practice, what impact that has had down the years. It's quite difficult really to assess what influence it has had.
Because you don't know what could have happened had it not been
exactly.
there.
Had it not been there, could things have been different? It's difficult to know that. But what the government is doing in the new Bill of Rights is it's narrowing Section 13. And so we have questions for the government over its justification for doing that. What is it seeking to achieve? What problems has Section 13 caused as it stands? And what might be the unintended consequences of narrowing Section 13? And Section 13 is something the Institute fought for in the original Human Rights Act when it was going through. So we're concerned to see that change. We want to press the government on its justification for it.
And we know that, it has been cited, it has been used in Parliament as an area of caution to not proceed with particular that particular
that's
policy?
a really important point in the context of certain legislation when it was being discussed in Parliament, including the legislation introducing same-sex marriage. Concerns about religious freedom were in part it was said there was no need for those concerns, in part because of the existence of Section 13.
Mm-hmm.
So if you're then changing Section 13, then that assurance that was given previously, is obviously significantly weakened. Just to say one final area of concern with the bill, it's not actually in the bill itself as it stands, but there's been a commitment by Stella Creasy, MP, who's very strongly pro-abortion, that she would seek to amend the bill as it's going through to introduce a human right to abortion. So that's something we're obviously very concerned about and we'll need to keep a close eye on. And
we'll speak again on this, no doubt, and we'll be sending out materials to supporters when we have them about the Bill of Rights bill. Well, just remains to say thank you, Dave and Sam, both for your time. Thanks.